Hello, everyone. Hello, everyone, and welcome to our webinar on the advisory proceedings before the International Court of Justice regarding state obligations in the context of climate change. My name is Jose Rodriguez Sorue, and I am part of the World's Youth for Climate Justice, and I'm honored to moderate today's session. We have an incredible lineup of speakers today, renowned legal experts, advocates, and state representatives who have directly engaged in or contribute to the ICJ proceedings on climate change, who are ready to share their invaluable insights. Before we dive in, a few housekeeping points. If you need live interpretation, please keep in mind that we have that option ready for you. We will have live interpretation in Spanish throughout the whole webinar. Some of our esteemed speakers may need to leave early, so we advise you to have any questions you might want to raise for the panelists in the chat, and I'll be ready to post them when the time comes. You're welcome to submit questions in the chat at any time. And we'll have a Q&A question at the end of the webinar. Now, first, some context. This webinar follows the historic ICJ hearings that ran in December 2024, during which 96 states and 11 international organizations presented their arguments before the International Court of Justice. It's an unprecedented moment for global climate justice, marked by an extraordinary engagement from youth, women, indigenous peoples, and countries from around the world, with many from the global south participating for the first time in an ICJ case. Originally envisioned by 27 law students from the Pacific and campaigned for by youth from around the globe, this has grown into the most significant climate case in the world. The upcoming advisory opinion could be a turning point for clarifying state obligations, reinforcing human rights protections, and safeguarding the future of vulnerable communities and generations to come in the face of the climate crisis. While the court deliberates our session, which is co-hosted by the Center for International Environmental Law, World's Youth for Climate Justice, and the Pacific Island Students Fighting Climate Change, aims to reflect on the hearings and consider next steps toward accountability and optimal outcomes of the advisory opinion. We'll have two calls, this one and one scheduled for tomorrow at 7:30 a.m. UTC. Now let's get started. Our first speaker is Margareta Weverinck-Singh. She's an associate professor of sustainability law at the University of Amsterdam and an attorney at Blue Ocean Law. She also represented Vanuatu before the ICJ. Margareta, the hearings in December have been described as historic. We were wondering what stood out most for you in the hearings, and could you please share what you think the advisory opinion, but also the considerable alignment we saw in the proceedings of many states might mean for future legal strategies or collaboration around climate issues? And in these uncertain times, what would you say are the implications of such proceedings for the rule of law and multilateralism?
Thank you very much, Jose, for these great questions. And thank you also to you all for organizing this webinar, which is, of course, very timely. Let's take just a few steps back to remind ourselves of what we were trying to achieve with these proceedings. So when it comes to climate action, there was, of course, the Paris Agreement, and the Paris Agreement contains many important provisions, but it also created a bit of a myth, namely that climate action was a matter of voluntary commitments of states. And so these proceedings were really intended to break away from that paradigm and to show that international law matters and that international rules and principles apply to climate change, and then not just the Paris Agreement and the Climate Change Convention, But the full spectrum of international obligations, including obligations derived from international human rights law, from other parts of environmental law, the law of state responsibility. And so by applying these various areas of international law to the conduct of states that has caused climate change, essentially what happens is you draw a line in the sand. And so you become then able to distinguish between what is allowed under international law and what is not allowed. That's drawing the line in the sand. And what was really important to see at the hearings in December is that the vast majority of participants converged around this understanding that international law applies in full. It's not just the Paris Agreement, it's a whole spectrum of obligations. These obligations set clear standards for states' behavior, and when states do not meet these standards, they are in breach of these obligations and incur legal consequences. And that's very broadly speaking the obligation to cease the unlawful conduct, and then also the obligation to repair the harm caused by that unlawful conduct. And so that is a very important climate justice element of the question that was put before the court. Because of course, in today's world, unfortunately, the reality is that those who have contributed the least to climate change bear most of the consequences, and polluters are not really held accountable for the harm that they have caused. So this is meant to accomplish a shift, and we see that so again, a majority of participants share this understanding, of course, with a few outliers. And then now we have to see, of course, to what extent this understanding will also be reflected in the court's opinion. But there are reasons to be hopeful, because ultimately it's a question of simply applying the law to the facts. And the International Court of Justice can be trusted with that task. And so the likely outcome then, or the likely impact of these proceedings on these various areas, again, it will depend, of course, on what exactly the opinion will say, but we may expect to see an impact on the negotiations, and then hopefully on these two fronts, that is prevention and reparation. So the question itself, if you study it carefully, you see there are essentially two dimensions about having to prevent future harm, and it's having to repair harm that has already been caused, or that may be anticipated through adaptation. And so the negotiations, you would expect to see greater ambition in NDCs. Many states have not yet submitted an updated NDC. And so we expect to see that the level of ambition goes up as a result of what the court has to say about what states need to do as a matter of obligation. And then also when it comes to adaptation, and I should mention finance also, because finance is of course a critical enabler of ambition, and the duty to cooperate is also a very relevant obligation that also requires developed country parties to these treaties to provide technology, finance, capacity building to developing countries to enable the necessary level of ambition. And then, of course, when it comes to adaptation and loss and damage, there's a loss and damage fund with negligible resources at present. So you'd expect to see significant funds, finance going into that fund to actually enable developed countries to start addressing loss and damage in earnest. And in terms of regional cooperation, there may be new initiatives based on also alliances that have been created or strengthened during these proceedings. There's a lot of potential there. And then, of course, when negotiations don't deliver, states do not voluntarily do what the court indicates they need to do, then there are other options to approach the ICJ again or other international courts or tribunals with cases. Could be other requests for advisory opinions, but could also very well be contentious cases against essentially recalcitrant states that need this extra prod. And then, of course, that's a whole different conversation. But it would be, I think, very surprising if the opinion would not provide some new ground for legal initiatives should those be needed. I'll leave it at that and look forward to the questions.
Thank you so much, Margareta, for your wonderful intervention and reflections. And yes, I think for many of us who have been involved in the climate space, we all often carry a sense of pessimism, especially around the outcomes of political processes. But just being there in the ICJ hearings, it was very uplifting, at least for me, and I know a lot of our colleagues that were covering the hearings, getting the sense that there was a big consensus around crucial issues for climate justice, such as responsibility for harm, prevention, as you mentioned, and the protection of human rights in the context of the climate emergency. So that's very important, and also seeing how this consensus can also flow into the political processes at the COPs is something we're very much looking forward, and also the potential litigation internationally and domestically, even if it's something that should be the last resort. It's also, we're hoping that this advisory opinion may contribute to better climate policies around the world. So thank you so much for your intervention. We already have some questions in the chat, just remembering that you can drop in any question at the time you want. And maybe we could just very briefly go to this one. It's related to the Inter-American Court's advisory opinion. Maybe if there's a quick reflection on how that relates to the ICJ proceedings, on how this can be strategically used to raise ambition. Just very briefly on that, Margareta, if you would like.
Yes, of course, we're waiting for the outcome in both proceedings. Of course, the questions posed are very different. In case of the Inter-American Court in particular, we would hope to see a strong focus on the right to a healthy environment, as well as reparations for various forms of harm. So that may be monetary compensation for quantifiable harm, but also we'd hope that the Inter-American Court draws on its rich jurisprudence on reparations for violations of indigenous rights and other environment-related forms of harm, where courts around the world could draw inspiration in crafting remedies for climate harm in rights-based cases.
Thank you very much, Margareta. And we'll have a Q&A space at the end as well, so other panelists can also intervene on that question and any others that come up in the chat. Next, I'd like to welcome Patricia Galvao Teles. Patricia is a legal advisor at the Portuguese Ministry of Foreign Affairs, with first-hand experience representing Portugal at the ICJ. Patricia, we saw the issue of sea level rise foregrounded in several interventions before the court. And in Portugal's intervention before the ICJ, you highlighted the work of the ILA and the ILC on climate change-induced sea level rise. From a European perspective, how do these proceedings intersect with the region's priorities and challenges around climate change, and especially around climate change-induced sea level rise? And how might an ambitious ICJ advisory opinion strengthen the work of the ILA and the ILC on the issue of sea level rise?
Yeah, thank you. Thank you so much for the kind introduction and for the questions. I'm really happy to join this panel today. It's really interesting to be able to take stock of what happened during the written and oral phase of the hearings while we wait for the opinion eagerly. I think we're all eagerly waiting for the ICJ's advisory opinion and of course also the Inter-American Court's opinion after a first good start with the ITLOS advisory opinion, which was also a very successful exercise and a positive opinion. So I'm really happy to join the conversation today with so many wonderful colleagues. And I have to apologize in advance that after I speak, I'm going to have to leave because I was called for a meeting that I was not expected. So I won't be able to join the discussion afterwards. But let me just say, I mean, I was privileged to represent Portugal in the hearings in December and also preparing the written submission. I also am very privileged to have additional hats, including as member of the ILC and as member also of the ILA committee that has been working on sea level rise. So I've been able to see the synergies between these processes, and I think it's a very interesting experience on how different institutions with different mandates in the end can contribute to working towards a similar goal, which is to clarify the law, to develop the law, to help with the interpretation of international law in the context of climate change and its impact. So this has been really a unique situation where we've had so many processes, not only just within the Paris Agreement framework, as Margareta was explaining, but also in other institutions with mandates that are not judicial mandates, but also contributing to advancing our understanding of the law and the interpretation of the law. And so I have to say from our side, and regarding your the aspect of the question about how do we see it also from an European perspective. I mean, from the side of Portugal, it was quite clear from the beginning that we wanted to participate in these proceedings. And like many other states, it was the first time for Portugal to participate in advisory proceedings before the ICJ. We had been in contentious cases that were brought by Portugal or against Portugal, but it was really the first time that we were participating in advisory proceedings as with ITLOS. Because we thought that not only we were doing it in solidarity with states most affected, including Vanuatu and other Pacific Island states and Caribbean states, and we also, Portugal also joined the core group in New York that was negotiating the resolution, but because we also see ourselves as climate vulnerable states. And I think it's very important that although this opinion was initially driven by Vanuatu, I think many other states identify also with being climate vulnerable states, and IPCC reports certainly put Portugal in that position, including with regard to the increase on the average temperature, sea level rise, coastal erosion, heat waves, water scarcity, and drought, and also more frequent and more intense forest fires. And in fact, I mean, we've been also already involved in climate litigation in the European Court of Human Rights in the Duarte Agostinho case, which was a case brought by young people from 6 young people from Portugal against not only Portugal but also other European states. I mean, the end result was not very forthcoming, but you see with that kind of litigation and also with the Swiss case how the European states are also not only feeling those vulnerabilities, but also the population is mobilizing, and that's also a very important aspect. The other aspect that I will touch just briefly is on what you mentioned, more specific on sea level rise, which is, of course, only one of the adverse impacts of climate change. One that maybe it's specific in the sense that it has the potential to affect the elements of the state and even the continuity of some states. And so the International Law Commission, following the footsteps of the very useful work that had been done by the ILA, has taken up this issue. And I'm happy to tell you that we've just produced our final consolidated report that will be discussed in the ILC this spring, and then by the General Assembly 6th Committee in the fall. And indeed, there's a lot of synergy, and that's what I think it's been really interesting in this process, because not only the ILA paved the way for the work on sea level rise, and of course, being a private body, it has more freedom, it can push boundaries further, but the ILC benefited a lot from that work. But we've also benefited enormously, and I think that maybe now the reverse will also be true in terms of how much the work that the ILC has done, which in fact has been picked up already by many states. If you think about the declarations by PIF on the continuity of the preservation of maritime zones and the continuity of statehood and protection of persons, and declarations that were also echoed by other organizations like AOSIS, we're now seeing a clear path legally in terms of affirming the preservation of maritime zones, in terms of continuity of statehood, and of course, a clear affirmation of protection of persons affected by the phenomena. And this has also benefited, in our final report, includes a lot of state practice, what we can call state practice, which is also coming from the statements that states were making before the International Court of Justice. So we don't have yet the final advisory opinion, and probably the opinion will come at a point where we will be already finalizing our work, but we're all hoping also that the court will also look at our report, which will come out in April, so maybe before the opinion is out. But this is really an interesting process on how different institutions with different mandates have come together, have influenced the practice, has resulted in a process of international law not being so reactive, but being a more proactive. And hopefully, as you said, an ambitious advisory opinion on this subject will really help in the clarification of the legal impacts of climate change adverse impacts. And of course, with that, bringing more certainty, stability, and predictability, and with that, the potential of avoiding conflict. So I'll stop here, and I'm really sorry because I'm going to have to go, and so sorry I cannot listen to my other panel panelists' presentations and to the Q&A, but privileged to be with you today. Thank you.
Thank you so much, Patricia, and thank you again for joining us. The importance of certainty and legal stability has been highlighted by many states in the ICJ proceedings, particularly around the issue of sea level rise. So yeah, I was going to ask the question that was put on the Q&A, but you already answered the potential for the ICJ to specifically address this as an impact, but also the legal consequences that may arise from that. And I think we can have some more comment on that from Zachary on how this impacts small island developing states. But truly, climate change in general and sea level rise specifically affects everyone, but not in the same way. And this was something that was also highlighted in the interventions of states, the importance to have an intersectional approach when talking about climate change impacts, and specifically around human rights violations arising from climate change. And on that point, I would really like to hear from David R. Boyd. David is an associate professor of law, policy, and sustainability at the University of British Columbia, and he's the former UN Special Rapporteur on Human Rights and the Environment. David, we've seen the right to a clean, healthy, and sustainable environment highlighted as a central theme in these proceedings, with a specific question raised by Judge Aurescu at the last day of the hearings. Why do you think the right emerged as a key issue in state arguments? And what would be the real-world impacts if the ICJ underscores this right in its advisory opinion? You also took part as an expert in the people's hearings. Could you also please tell us a bit about these hearings and their significance in relation to the AO proceedings?
Bueno, muchas gracias, Jose, and thank you to the World Youth for Climate Justice and the Center for International Environmental Law for organizing this webinar. It's really an honor to be with so many of my heroes in the climate movement here today on the panel. Friends and colleagues, I think the first thing we have to say with absolute clarity is that we are living in a climate crisis, which is also a human rights crisis. And this was illustrated in such compelling fashion by the testimony of 18 witnesses at the People's Assembly in parallel to the ICJ hearings in December. These witnesses from frontline communities experiencing the devastating impacts of the climate crisis, which is disrupting their lives, the lives of their communities, the lives of their countries. These are people from Tuvalu, Vanuatu, Kiribati, Libya, Sudan, Mozambique, Cabo Verde, Aruba, Honduras, Colombia, Ecuador, Greenland, Pakistan, India, countries that really are facing these horrific human rights impacts on the right to life, the right to health, the right to food, water, sanitation, cultural rights, the rights of the child, the rights of indigenous peoples. And so hearing the stories and integrating their testimony into the People's Petition, which includes their stories plus international human rights law, was a way to put a human face on the climate crisis for the International Court. And Vishal Prasad from Fiji presented this testimony in his presentation to the court on behalf of the Pacific Island Forum. And the power of bringing a human rights-based approach to the climate crisis is not only that it puts a human face on this horrible problem, but also that human rights brings powerful law to bear to enable us to hold states accountable to the commitments they have made but not fulfilled over the past 40 years. And so, you know, we had the groundbreaking precedents of the Urgenda decision of the Supreme Court of the Netherlands, the Constitutional Court of Germany, the Neubauer case, which compelled governments to take more urgent and ambitious climate action. And while there is a broad spectrum of human rights implicated by the climate crisis, it is my opinion that the most powerful tool in the human rights toolbox is the right to a clean, healthy, and sustainable environment. Because not only does this right include clean air, safe and sufficient water, healthy and sustainably produced food, non-toxic environments where people can live, work, learn, and play, healthy ecosystems and biodiversity, but also a safe, livable climate. And that is so essential. And that has been highlighted by courts around the world in Hawaii, Montana, the Supreme Court of India, as well as Colombia, Ecuador, and most recently, a case from South Africa in which the court struck down the authorizations for new coal-fired power plants because they violated the constitutional right to a healthy environment in South Africa. We have empirical evidence generated by scholars that climate litigation, which includes the right to a healthy environment in its pleadings, has a higher likelihood of success. And so when we turn to the advisory opinion of the International Court of Justice, really what I believe to be the most important legal proceeding in human history, it was encouraging to see that the resolution adopted by the General Assembly, which sent these questions to the International Court of Justice, specifically referred to the human right to a clean, healthy, and sustainable environment. And as a result, in the written and oral submissions of states to the court, more than 50 states made very strong arguments that the right to a healthy environment is critically important for identifying the obligations of states to address the climate crisis. And there were only a handful of opponents led by the United States, the United Kingdom, Russia, Saudi Arabia. Interestingly, as you mentioned, Jose, on the final day of the hearings, Judge Orescu asked the question of what is the legal content and relevance of the right to a healthy environment to these proceedings. And this generated an absolute flood of submissions. Over 120 states and international organizations made very compelling arguments about the content and importance of the right to a healthy environment for this International Court of Justice advisory opinion. The majority of those states concluded that the right to a healthy environment has become a keystone of customary international law, which establishes binding obligations upon states. So while the United States may be able to walk away from the Paris Agreement, they cannot walk away from their international human rights obligations. And as of today, 164 of the United Nations 193 member states recognize the right to a healthy environment through a combination of constitutions, legislation, court decisions, and regional treaties. There's another 15 or so small island states that strongly support this right, but have not yet incorporated it in their domestic legal systems. So in total, approximately 180 nations, or 93% of the UN's membership, recognize the right to a healthy environment. And so our clear hope, and I'm an optimist, so my belief is that the International Court of Justice will recognize that the right to a clean, healthy, and sustainable environment is a critical part of the international human rights framework, and that it establishes clear and binding obligations upon states to take more urgent and ambitious and rights-based climate action in the years ahead. That has concrete ramifications. It means an end to subsidies for the production of fossil fuels. It means an end to the construction of new coal-fired power plants. It means an obligation to provide the maximum available resources to protecting human rights from the growing specter of the climate crisis. And my time is up here, but I just want to say in closing, friends and colleagues, that in this moment in human history, those of us who believe in peace, justice, human rights, and a sustainable future for all have to build a global coalition of unprecedented size and scope to secure the sustainable future against the forces of darkness that are trying to steal that from beneath our very feet. Thank you very much, and I look forward to the conversation.
Thank you so much for David's intervention and for your optimism. I really was also felt really good seeing all these state arguments after the Judge Orozco's question, highlighting, as you mentioned, that the right to a clean, healthy, sustainable environment is part of customary international law, and 9 states that have not yet codified that internally recognize that before the ICJ. So we see that there's a growing momentum that already passed to the UN Human Rights Council and through the UN General Assembly, recognizing this right. Now going through the world's highest court, which has the responsibility to take this step. And the issue of how this relatability is very important, because some states, the majority of states, also highlighted that human rights obligations go beyond state borders, highlighting the issue of extraterritorial human rights obligations and looking into the Inter-American Court's advisory opinion on the environment. It's so important for climate accountability that those who are most responsible for the damage to communities can be held to account, that international law is alive to that possibility to have any sort of legitimacy in the face of climate change. And to that point, I would like now to turn to Mr. Alfonso Asensio. He's Deputy Head of Mission at the Embassy of Mexico in the Netherlands. Alfonso, Mexico presented strong arguments on a harmonious interpretation of international law and on state accountability for climate-related harm. Could you please expand and explain the relevance of these arguments for Mexico in particular and Latin American countries in general? And what would you consider is the significance of these historic ICJ-AO proceedings?
Well, thank you, Jose, and thank you very much for those 2 very good questions. Firstly, I wish to express our gratitude to the organizers for this kind invitation, and also I'd like to state that it's a privilege and honor to participate on behalf of Mr. Pablo Arrocha, who's the legal advisor of the Mexico's Ministry for Foreign Affairs, who many of you know and have met, and Mr. Arrocha conveys his kind regards. And lastly, I have to say that my participation is on an individual capacity, and my remarks may not necessarily reflect all aspects of Mexico's official position. But before responding to your questions, if I may, I would like to highlight that Mexico had an active participation in this process. First, it co-sponsored the request for an advisory opinion by the UN General Assembly through Resolution 77/276. And second, in the context of the ICJ proceedings, it participated in all its written phases and oral phase. including by giving written response to the questions posed by judges Cleveland, Tadley, Orescu, and Charlesworth, which is they refer much to the question posed by Judge Orescu. All these materials that Mexico presented are on the website are public and available on the ICJ's website. Now, as for your first question on harmonious interpretation, I have 3 points basically. First, regarding the question regarding the obligations of states with respect to climate change, for Mexico is one of the most urgent topics in the contemporary landscape. Let us remember that the General Assembly, in the very first preambular paragraph of its resolution, through which it made a request, recognizes that the climate change is an unprecedented challenge of civilizational proportions. Second, Mexico views international law as a unified legal system. In the context of the work of the ILC's study group on fragmentation of international law, it was concluded that international law is a legal system. Its norms act in relation to and should be interpreted against the background of other norms. And as a legal system, international law is not a random collection of such norms. In this connection, the ILC's conclusions also refer to the principle of harmonization. In this regard, Mexico believes that climate change treaties should be harmonized with general international law principles to address the complex nature of climate change. These treaties should be interpreted and applied within the framework of the entire legal system. In the advisory proceedings, Mexico submitted to the court that the obligations under climate treaties coexist harmoniously with the principles that underpin the international law as a unified system, since there is no actual inconsistency or explicit derogation from them. By embracing harmonization, the court can advance not only the objectives of climate treaties, but also the broader principles of international law. And my third point, of course, these arguments on harmonization naturally also apply to human rights law, as we just heard, and the law of state responsibility, as Margareta mentioned in the beginning. On human rights, basically David made a very powerful intervention in this regard, and I will not attempt to do it as well as he did. But I would like only to add and recall that the ICJ stated in its advisory opinion regarding the legality of the threat or use of nuclear weapons that the environment is not an abstraction, but represents the living space, the quality of life, and the very health of human beings, including generations unborn. Now moving to the issue of state accountability of climate-related harm, Mexico emphasized to the court that the general rules of state responsibility apply, and at this juncture, I would only deal with one point raised by Mexico on the legal consequences for breach of international obligations, and that is related to the obligation to provide adequate reparation. Given the often irreversible nature of climate change, compensation becomes critical. While compensation is still an open question in the negotiations on climate change, the advisory opinion should spell out the obligations arising from the rules of state responsibility for reparation purposes. Now moving to your second question relating to the significance of the ICJ proceedings, I would like in this regard to distinguish 3 segments. First, the significance and relevance for Mexico. The advisory proceedings hold a great significance for Mexico, and Mexico is confident that they will have a positive impact for all stakeholders. And second, the significance to the work of the General Assembly itself. In the end, it should be recalled that the advisory opinion was requested by the UN General Assembly, and one key aspect of the advisory function of the court is to give its opinion to the organ that requested it, being the case the General Assembly. The reply of the court will represent the participation of the court in the activities of the organization. Although the advisory opinions are not binding, regardless of that, the opinion will have a major authoritative influence within the work of the GA and the broader UN system. In this connection, the ICJ's findings could guide and enrich the drafting of the annual GA resolutions on the protection of global climate for present and future generations of humankind. And by doing so, the ICJ's finding could also contribute that the future resolutions on the subject carry a greater legal weight. And third, the significance of the advisory opinion to the international community as a whole could be captured in two aspects. First, it provides a unique opportunity to state the law and consequently the ways in which the states must conduct themselves in fulfilling their international obligations. And second, the court, as a principal judicial organ of the United Nations, has a truly historic opportunity to make a huge contribution to the fulfillment of the principles and purposes of the UN Charter. I will conclude by recalling the words of Mr. Pablo Arrocha, who's the legal advisor of Foreign Affairs of Mexico, that he made in the oral hearings before the court. At a time in which we are facing the greatest climate and environmental crisis of our collective history, the advisory opinion to be rendered by this court will define the present and shape the future for global climate justice. Thank you.
Thank you, Alfonso, and thank you for sharing what Mexico presented before the ICJ. And it's very important that you make this point around how international law is a system which is not only about the Paris Agreement, a point already highlighted by Margareta earlier, and that other branches of law need to be taken into account when dealing with this very complex issue, especially when some states argued that the Paris Agreement and the UNFCCC treaties were lex specialis. That is, they were in conflict with other broader rules of international law, and thus were the only applicable legal framework. So it's very important, the arguments Mexico made around responsibility. And also, I think that relates to another point that was made a lot by women, indigenous communities, and a lot of states that come from a context of historical exploitation and violence, and have gone through a process of decolonization, and how that process also relates to how climate change impacts are experienced in the lived realities of people. And on that point, I would like to give the floor to Kate McIntosh. Kate is an executive director of the UCLA Law Promise Institute in Europe. And Kate has also represented Palestine before the ICJ. Kate, Palestine highlighted a particular important issue that is often overlooked: the linkages between armed conflict, occupation, and climate justice. Could you speak to these linkages and discuss what the breach of climate-related obligations in the context of armed conflict, other military activities, as well as occupation, means for state responsibility under international law?
Yes, absolutely. Thank you, Jose. And hi, everybody. I must say it's such a pleasure to dip a toe back into the amazing atmosphere and experience of these climate hearings in December, which were really, as you described so well, Jose, really wonderful and quite unprecedented. So I had the huge honor to be part of Palestine's legal team. And the goal of the Palestine submission was really this: that if the judges of the International Court of Justice are to make a definitive statement about state obligations in the face of the climate crisis, they have to take into account the situation of people in armed conflict and under occupation. And this is actually in itself a question of climate justice, because people caught up in armed conflict and under occupation are among the most vulnerable of us. So our arguments can be boiled down to three main points. First of all, that the principles of general international law that are relevant to the protection of the environment, including the climate system, also apply in armed conflict and occupation. Secondly, that the principles of international humanitarian law relevant to the protection of the environment in armed conflict and occupation apply to the climate system. And thirdly, we invoked the right to self-determination, and we invited the court to consider the inability of an occupied state to respond effectively to the climate crisis as one significant consequence of the denial of that right to self-determination. So in the interest of time, I'm going to focus mainly on the second point, but briefly on the first. Our submission was that the fact of armed conflict or occupation does not displace the general international law obligations relevant to the protection of the environment, which my colleagues have already detailed so well, and that, on the contrary, the climate crisis requires the application of the same stringent standard of due diligence to the protection of the global environment in those situations, so including protections from emissions generated by armed conflict and other military activities, as well as occupation. And as I'll detail in a moment, these emissions are quite significant, and they don't currently feature either in the mechanisms of carbon accounting nor in the understanding of conflict-related environmental harms. So to our second point, which is that the principles of international humanitarian law relevant to the protection of the environment in armed conflict and occupation apply to the climate system. There's been much work on the protection of the environment under IHL and in armed conflict more generally in recent years. Most notably, the International Law Commission, and Patricia was part of those efforts, issued its draft principles on the protection of the environment in relation to armed conflict in 2022. But also there was important work done by the ICRC, for example, who issued their revised guidelines on protection of the environment in 2020, and the framing and investigation of environmental war crimes or serious violations of IHL protection of the environment, has been given new impetus recently by developments in the Ukraine conflict and also in the policy paper that's being currently developed by the prosecutor of the International Criminal Court. So our key argument, as I said, is that this protection of the environment in these and other instruments has to be understood to include protection of the climate system. And that's probably an uncontroversial statement to many people watching today. And it's certainly in line with the ever-increasing understanding that the pollution, biodiversity, and climate crises are interrelated, as well as in line with the legal opinions, such as that from ITLOS, of course, finding that greenhouse gas emissions should be considered marine pollution under UNCLOS. But it has not been expressly articulated that climate harms are envisaged in these protections. And so we explicitly asked the court to do so. So what would that mean for state responsibility? How is the environment protected in armed conflict? Well, there are specific rules protecting the environment in IHL, so rules which actually talk about the environment, including the absolute prohibition on causing widespread long-term and severe damage. However, the environment or the natural environment, lots of debates about those terms, is also considered to be civilian in character. So constitutes a civilian object, and that triggers all the protections that are offered to civilian objects under IHL. In other words, it's not only rules which specifically mention the environment that are relevant to its protection in armed conflict, but also, for example, the rules on targeting, on precautions, and on proportionality. And this is explicitly stated in Principles 13 and 14 of the ILC's draft principles, which I just mentioned, and also in the ICRC's customary international humanitarian law study as Rules 43 and 44. So our submission is that these rules, which are generally accepted, equally apply to the climate system. So looking at some of the most relevant provisions, which I just mentioned, we might read them as follows. There is an absolute prohibition of widespread, long-term and severe damage to the climate system in situations of armed conflict and occupation. There is a requirement to take precautions in attack, so to take all feasible precautions in the choice of means and methods of attack with a view to avoiding and in any event to minimizing damage to the climate system. The principle of proportionality, which would mean refraining from launching any attack which might be expected to cause incidental damage to the climate system, which would be excessive in relation to concrete and direct military advantage anticipated. And perhaps underlying all of these, the basic rule that in any armed conflict, the right of the parties to that conflict to choose means and methods of warfare is not unlimited. So we think this could be, really significant, as the impact on the climate system of armed conflicts, as I shadowed earlier, is really quite considerable. As we set out in our submissions, in just the first 4 months of the conflict in Gaza, it was estimated that the equivalent of the total annual emissions of the 26 lowest emitting states was produced. So just the first 4 months of the conflict, equivalent to annual emissions of 26 of the lowest states. The destruction of farmlands, forests and orchards and their function of carbon sinks, of course, is another cause of harm to the climate system from conflict. And the mechanics of occupation, which in Palestine range from the uprooting of thousands of olive trees to the carbon-intensive construction of the concrete annexation wall, create emissions that also need to be taken into account. So to conclude, these conflict and occupation-related emissions need to be considered, first of all, as harms regulated by the rules on protection of the environment, applicable in situations of conflict and occupation. All the rules, the specific rules under IHL and more generally. And they also need to be reported on, because despite their significant contribution to the climate crisis, they're not counted in carbon inventories. And very finally, to return to my opening point and the overarching goal of our submission, if the impacts of conflict and occupation on the climate system are not both considered and regulated, then we effectively exclude the most vulnerable among us, those living in those situations, from the protection of the law. So I'll leave it there. Thank you very much.
Thank you very much, Kate, for that very powerful intervention. And it's so important to understand what you're highlighting. First, the linkage between the war machinery and GHG emissions, but more broadly, how international law has to, and its interpretation by the ICJ, has to be aware of those mechanisms in how power and its harm on civilian populations has also an effect in how human rights violations, but especially those relating from climate change, are experienced by people. And I also really like that you mentioned the diligent standard of due diligence. That was something highlighted by many other states. And the point being that it is not only about the Paris Agreement, and that there are other areas of international law that inform the duty of care that states have to undertake when taking climate action. And in this case, they have more stringent obligations, being an occupying power. So it will be very, very important to see also how the ICJ relates to its already existing broad jurisprudence on self-determination and IHL. Already some indications in previous advisory opinions in Chagos, and also the nuclear weapons advisory opinion. So I think this will be a very important point for the ICJ to consider. Thank you so much, Kate. I will now turn to Louise Fournier. She's a legal counsel for climate justice and liability at Greenpeace International. Louise, civil society organizations have played a critical role in the ICJ proceedings. Could you please briefly describe the role of civil society in these proceedings? And in your view, what are some of the key aspects to highlight from the hearings in relation to what happened, both inside and outside the courtroom? And as a movement lawyer, what do you think an ambitious advisory opinion could mean for climate justice? How can civil society take the forthcoming opinion forward in their work?
Thank you so much, Jose, and good morning, good afternoon, good evening to everyone. It's really an honor to join you virtually. And I want to start by echoing the thanks of the panelists, specifically to the Pacific Islands Fighting Climate Change and the World Youth for Climate Justice and CIEL. So as we know, youth really spearheaded this unprecedented demand for climate justice and was central in making sure that there was an advisory opinion on climate change. And as legal counsel for Greenpeace International, I'm really grateful for this invitation to share a little bit more about this role that civil society played, and also what we believe at Greenpeace would be an ambitious outcome and what it could mean for climate justice. And in our view, civil society really made 3 core contributions to the proceedings. Firstly, it really grounded the ICJ advisory opinion into the lived experiences of people that are impacted by climate change and their demands for dignity. but it also used the power of storytelling, and I will tell you a little bit more about this. And finally, it demonstrated how we can use the power of people to request a progressive advisory opinion, and I will share a little bit what we think it could mean for the climate justice movement. So as I was saying, one of the key aspects of civil society's involvement was really to ensure that we brought the real life experiences of impacted people to the court. This was at the heart of our efforts, and as Jose said, it was really based on this movement luring understanding that those who are closest to the problems also are the best suited to find the solutions to it. But I can assure you that there were a lot of institutional challenges to these objectives. Specifically also in terms of who is allowed to be heard by the ICJ, who is seen as an expert, and what is considered evidence. This is the world's highest court, but it's also de facto one of the most conservative courts. But we didn't let these barriers stop us, unsurprisingly. So at the same time as the oral hearings were happening, as David mentioned, youth and partners organized the People's Assembly, which was a place for frontline communities and representatives to speak of the realities of the harms that they have been experiencing and continue to suffer because of the climate crisis. And what the organizers did was to ask the people who testified there to talk about what justice means to them and what they have seen and what also their families and their communities have seen and lived. And what we wanted to do was to ensure that there was a space to actually align the law and its interpretations with the actual necessities of the world that we live in. And in doing so, what we want to make sure is that we also work with more than one definition of what justice is, but that we actually honored the cultural and spiritual diverse definitions of the words justice and dignity, including, of course, indigenous ones. And by documenting these community wisdoms, indigenous practices, the testimonies really emphasize that the necessity of aligning these legal outcomes that we're expecting with actually the needs and aspirations of those who are on the front lines of the climate crisis. And as David mentioned, the outcome of this was the People's Petition, which was created and shared also with the ICJ and recapped these communities' demands and aspirations and lived experiences. And the overarching purpose of this is really to urge the ICJ to prioritize the realization of human rights when they're going to define the obligations of states in relation to climate change. I think if there's one quote that is worth reading out loud from the People's Petition, it's this one, and it's short. This moment is not just about legal principles, it's about preserving the dignity of humanity itself. The People's Petition is not merely a document, it's a symbol of solidarity and resilience, and it's a demand for justice that transcends borders. It's a call to act boldly, decisively, and urgently for today, tomorrow, and for generations to come. I really urge you to read the People's Petition while we're waiting for the ICJ advisory opinion. It's really powerful to read these testimonies, and it's just a treasure. The second element that civil society really brought was its very closely linked. It's the importance of storytelling, because we really believe that making space for sharing stories, it's critical to humanizing the climate crisis, to foster solidarity, but also very crucially for communities to reclaim their agency in this process by elevating the power of stories, just as important as other forms of evidence or legal arguments. So in doing this, we made sure that some of the events that we had outside the courtrooms, like the candlelight vigil and a Talanoa dialogue, were there to honor the brave individuals who are fighting for climate justice, and also, of course, remembering those who we lost. We had other events like the People's Museum, which invited visitors to actually bear witness and hear the stories directly from impacted communities and displayed artifacts of these communities. And it became one of those spaces where communities reclaim their story and also reframe what is passed on and what should be preserved in the face of the climate crisis. And so other events from the impacted videos, the videos of impacted people at the witness stand, to one of the Greenpeace ships actually going around the Pacific Islands to collect the stories of impacted people, really made sure that both inside and outside of the court, we went beyond abstract legal theories and really looked into the heart of the matter and what are the stories that people are saying. In terms of all this, what does it mean for us, civil society? What will happen once the advisory opinion is out? And what, Jose, you asked, what would a progressive advisory opinion actually look like? I think from our side, really a progressive advisory opinion would not talk about, abstract legalities in a vacuum, but actually address critical elements of the climate crisis. In doing so, if it could give clear guidance on, for instance, emissions reductions based on the best available science, on the obligations of states to adapt to the impacts of climate change, on, we hope, also mentioning the responsibility of major polluting industries, and crucially also addressing the loss and damage and historical responsibility of states, as Margareta mentioned. And ultimately, what we believe is that a favorable advisory opinion, one that aligns with these principles, would really contribute to the progressive development of international law and climate action, integrating scientific knowledge with human rights principles, but also community knowledge and indigenous knowledge. And we know that the advisory opinion will be used as a guiding tool, as a powerful tool for all of us, for legal practitioners, for policymakers, for civil society. But what we want to really stress is that the advisory opinion is not only for lawyers and politicians and academics, it's really for everyone. And that's one of the key roles that civil society can actually do, is to democratize and popularize the outcomes of the advisory opinion. And to do that, I think the final message is really that we have to continue to ensure that the lived experiences and the concept of dignity really remain central to any follow-up work of the advisory opinion, by also making sure that when we're in the next phase of discussing and brainstorming how we're going to implement the advisory opinion, we really rely on and take the lead from those who are the most impacted from the climate crisis. Thank you so much.
Thank you so much, Luis, for all your amazing work and for sharing your perspective with us. Youth and civil society have been so crucial in driving this from the very beginning. And from the youth point of view, we've worked tirelessly from different regions. Youth from around the world have lobbied states to vote for the UN resolution, and then also to convince them to participate. And not only that, to have a meaningful participation, as you mentioned, with other civil society partners, pushing for the inclusion of the lived experiences and realities of those most affected by climate change, which I think is so important for the judges to know that this is not only about legal theory, but this is a real threat to human beings that are already experiencing the effects of climate change right now. We saw powerful statements directly to the court from youth and indigenous advocates. We had Cynthia Hunihuri, who will be speaking in tomorrow's panel, also Vishal Prasad, Brenda Harrison from our African Front, and also Mert Kumru from Europe. And we also sent letters to the ICJ judges. It was just a mass mobilization of youth across the world and from civil society partners. Thank you so much for being part of that. And I think the ICJ is well aware of our message that this is a human rights crisis, and it has to take into account how human beings are being affected. And just to highlight as well the importance of the decolonial and intersectional approach to this and to climate justice, and incorporating not only best available science, but also ancestral knowledge of indigenous communities in how all of this opinion is articulated, because those who are disproportionately affected have to be part of the solution. And if you see these advisory opinions and the proceedings before ITLOS, before the ICJ, before the Inter-American Court of Human Rights, it's been those states most affected by climate change, a small line of developing states that have led these processes, seeking stronger standards for climate justice. And on that point, I would like to finally turn to Zachary Phillips. Zachary is a Crown Counsel at the Attorney General's Chamber in Antigua and Barbuda, who represented his country before the ICJ. Zachary, from the perspective of Antigua and Barbuda, these hearings are vital for survival. What are your main takeaways from the arguments presented? And if the advisory opinion is decisive, how might that reshape climate policy conversations in the Caribbean, but also globally? Specifically, how might the forthcoming opinion and even the alignment we saw with a lot of states around the world in the proceedings can impact COPs and support small island developing states in climate negotiations?
Thank you very much for having me. I have the unenviable task of going last, so I will do my best to be concise, but also to be engaging so that persons, enjoy the entire experience. So before I start speaking, the first thing that I have to say is that I am immensely proud and grateful for the leadership that the small island developing states worldwide have done in not only the ICJ process, but the advisory opinion processes around the world, including ITLOS as well. And I must specifically point out my great appreciation for Vanuatu and for the youth of the Pacific Islands, because it really was their initiative and their motivation that caused the rest of the world to join on in this very timely and necessary call before the International Court. Now, breaking your question to me into different pieces, you asked about the overall impression. And I must say, before I usually give responses of this nature, I always indicate that I wear a dual hat in Antigua and Barbuda. I am a lawyer at the Attorney General's Chambers, but I'm also part of the negotiating team in climate and other areas. So engaging with the advisory opinion was quite fascinating for me, because the engagement started from the core group process, as Antigua and Barbuda was a core group member, beyond to negotiating the text itself, the request itself, and then going on to spread the word to other nations, to civil society groups, to get that momentum flowing. And then on the inverse side, now switching on to the legal side, making those arguments, digesting the arguments against us, and seeing how best Antigua and Barbuda can make these arguments. So my takeaway is, and I'll be very brief because I think the meat of my answer should really come from the second part of the question, but I just really wanted to highlight how proud and exceptional of an experience it was for all small island developing states, because whenever I communicate this, people don't seem to really understand. A lot of the states from the SIDS who participated in this process, in the ITLOS process, we come from attorney general's offices that have 4 or 5 or 3 people who are supposed to follow all international affairs for the entire country. So it really was a gargantuan task. And again, extremely grateful for the assistance from other member states, from civil society, etc., because we couldn't have done this without you. But most importantly, very proud of the showing of our Caribbean brothers and sisters, Pacific brothers and sisters, and how they appeared before the court. Most persons, their very first time, and made such cogent, strong and convincing arguments to support the arguments and the results that we want to see. Now, that's a great segue in that when asked what would a strong advisory opinion look like to me, again, my legal brain kicking in, I wanted to juxtapose it to a lot of the arguments that we were seeing in the written statements that were directly undermining the arguments that we wish to make. So as a brief synopsis, those arguments can be grouped in 4 broad categories. The first is that climate change and its adverse effects are too complex to attribute to any act or omission of states. So that ties into the state responsibility arguments. A second, similar but bit nuanced arguments was the conduct that has caused significant harm to the climate system does not carry any legal consequences under the law of state responsibility. A third argument was the lex specialis arguments, which I firmly believe has been excellently rebutted. And the fourth argument would be the court should not interfere with the negotiations and or the political process surrounding the UNFCCC and its related regimes. Now, I think a strong advisory opinion would have to address what I call the low-hanging fruits, and then an excellent advisory opinion would address the high-hanging fruits. So with the low-hanging fruits, I would say the lex specialis arguments is easily refuted. The ITLOS advisory opinion has already done this, and many of the speakers that have come before me have spoken about the fact that international law does not exist in a vacuum. No silo of international law should exist on its own because it interacts and interplays with other obligations under other regimes, and the states and or the persons who are the subject of those obligations and rights have to exercise those obligations while acknowledging, respecting, and harmonizing their actions amongst other systems as well. So, as I said, we see very clearly the climate regime being lex specialis is not going to stand. And I do firmly believe that this will be a result in the ICJ advisory opinion clearly refuted. The second low-hanging fruit that I've identified is that the court should not interfere with negotiations under the UNFCCC regime. Now, before I give my answer, I must also state that a lot of rhetoric was surrounding the fact that this was an attempt by states who wanted to move away from the UNFCCC negotiations, who have felt slighted, disadvantaged, and no longer wish to continue. First and foremost, at this point, I can only speak for Antigua and Barbuda, but I'm sure I speak for many other states as well when I say that the ICJ advisory opinion was never meant to replace the UNFCCC negotiations. It is a kit, as I believe Dr. David Boyd said, it is an option in the toolkit. We have to look at the negotiations in tandem with other options available to us, such as these advisory opinions, such as bilateral negotiations, such as speaking to the international financial institutions, because the truth is we are at a state, especially for SIDS, where if significant action is not taken, we will not be here to continue participating in the negotiations. And I'm not being dramatic by stating that. There are literal island states that are below sea level, that are moving entire populations of people to other parts of the world because they cannot survive on the land that they were born on. And this is a reality that I try time and time again to explain because a lot of people do not understand. A Category 5 hurricane that passes over my nation, Antigua and Barbuda, at the same time will be passing over Guadeloupe, Dominica, Grenada, St. Kitts and Nevis, which are all also independent nations, but because of our size and the size of what it is that we have to deal with, this is the ramifications of what our small islands have to contend with, and why we are saying that more tools in the toolkits need to be used in order for us to get some sort of tangible results. So it is spurious to claim that the ICJ advisory opinion is all that we need, but rather it will be useful for us to address some of those issues that we're seeing arise in negotiations and other places. Now, what I've deemed as high-hanging fruits, if I could call it that, is that an ambitious advisory opinion would definitely have to wrestle with the question of attribution. Now, for the non-legally trained, attribution is literally discussing which states can be held responsible for which actions that caused the breach. We know that that is a very difficult area to deal with when it comes to climate change specifically. However, I do think that there is opportunity for the ICJ to give us something of use. Now, that ties into the question of state responsibility, or so I should say rather, the arguments that climate change is so complex that state responsibility cannot arise. That is a misnomer. That is incorrect. And I think the ICJ, by correctly deciding that that cannot be the case, will give us the necessary building blocks that can be used to address this difficult issue of attribution. Now, that does not mean that attribution cannot be overcome. I personally believe that the questions or the answers as surrounding attribution may not be addressed in an ICJ advisory opinion. However, I do not think that that means we are any less off if it isn't addressed. What should be focused on, however, and I think the court has enough arguments in their arsenal to make these proclamations is whether the court focuses more so on forms of reparation or forms of compensation that is available to state responsibility. Now, this is useful in two ways. One, compensation generally, I'm sure I'm not the only one who knows of the woes that are related to financing the climate action around the world. And these are woes that exist in developing, developed, coastal, landlocked. Every state around the world has difficulties with finding this finance. However, I think a clear proclamation from the ICJ would be most useful in helping us address this. Why? Because it would be based on legal positions. It would be based on climate responsibility. I would say that is a very, very, very important point, and I will tie it into my final piece of discussion. But it will also be based on, to an extent, consensus. Because if you look at the majority of arguments that have been put before the courts, yes, there are outliers, but none argue that state responsibility, one, is not suited, or forgive me, either they argue state responsibility doesn't apply, or if you apply it, you have the hurdle of attribution. There are very, very, very few outliers that argue that state responsibility just simply cannot apply. I would also like to raise at this point that I think the ICJ may need to go a step further to indicate a sort of temporal starting point as to when this right being, whether it be the rights of a clean and healthy environment, or whether we go further back to say a duty of due diligence, when would that right have crystallized, which would then mean that the breaches would result in state responsibility. Now, while I know that is a bit complex, I think that is more useful than just identifying action X is a breach or action Y is a breach, because then it helps for states to firmly make the arguments that you, not only is your action a breach based on this ICJ advisory opinion, but it's also clear from the ICJ that as early as the 1980s or the 1970s, as some states have argued, states worldwide were aware that action X would have been a breach. And therefore, you have been in continuous breach since the 70s or the 80s. And that is something that would be extremely beneficial. And on the last point, very quickly, concrete impacts for COPs for small and developing states. As a starting point, the most beneficial impact will be the supports, the bargaining power. A lot of people don't speak about it, but when you're in a negotiation setting, there is a lot of politics that exists from outside of the room that influence decisions inside of the room. And I think a lot of times, some member states, whether intentionally or not, attempt to renegotiate some of the very foundational principles that are in the UNFCCC and in the Paris Agreement as well. Now, I think having an ICJ advisory opinion would allow for states like mine, regardless of the fact if we have a manpower team of 200 people or not, we do have a document that is supported by not only the ICJ, highest court of the world, but also supported by civil society, most of the developing world, by the most vulnerable in the world, that says you are under an obligation to provide financing for X, Y, and Z. You are under an obligation to address the issues that we are bringing before you. And I'll use that to tie into sea level rise. A lot of connection is being made between loss and damage and the future implications for climate mobility. Because as it is right now, technically, or some would argue, adaptation doesn't really cover the responses to rising sea levels, because you wouldn't necessarily be adapting to a future harm, or some would argue because of the slow pace of rising sea levels, it doesn't constitute as an adverse effect that needs response in the moment. There's a lot of arguments. And most importantly, there's a lot of arguments within the financial bodies, because they are the ones who fund activities that states need to do to protect their most vulnerable. I think a decision from the ICJ that says specifically that loss and damage is a ramification or does fall under the responsibility of states who have been breaching for X amount of years. And also, rising sea levels is a result of the breaches that have been happening for years, will make it a lot easier for finances to be found and supplied to those who are most vulnerable and need it. I don't think many people are thinking about how much a state would have to budget and plan out to relocate the entire nation. And with that, I will end and open the floor for questions.
Thank you, Zachary, for that very important and comprehensive exploration of all these topics that arose and have particular relevance for Antigua and Barbuda, but also for SIDS and climate vulnerable countries around the world. That point you make on state responsibility, it's been so not only ignored in political negotiations, but also they've been actively trying, some big polluters have been trying to undermine whatever language may be of use to other states under the climate treaties. And in that, I feel a paradoxical contradiction when some states claim that some states, especially developing states from the global south, are trying to undermine the negotiation processes through this advisory opinion, when in this advisory opinion, some states, high polluting states, actually try to undermine the very language of the Paris Agreement of the UNFCCC, essentially a lot of them arguing that what they need to do is only to communicate an NDC, not comply with it. So it's very shocking to me that these arguments are being made, but it also makes very explicit the intention that is to shield them from the responsibility of the damage they have caused to this planet, and already people are suffering. So thank you so much for your intervention. And I do apologize to folks of the audience. We won't have time for questions, but there will be chances for more discussions down the line, and also on tomorrow's webinar, which we strongly encourage you to attend. But on a finishing note, I would ask each panelist if you could please give me a closing 2-minute address to what you think is the most important potential of the ICJ advisory opinion and what people should take home from the relevance of this process. Maybe we can start with Alfonso, then Kate, Luis, and then Zachary to wrap up. Thank you.
Thank you, Jose. And basically, yes, it's been a very interesting discussions where it's a lot of food for thought, I think, for all the panelists as well. And as I outlined at the end of my remarks, I think the significance of the proceedings have many layers. It has an impact at the national level, but also at the level of the General Assembly, which I think is very meaningful. At the end of the day, the advisory function of the ICJ is given to the organs or international organizations, which if they've been authorized to do so. So this is it will possibly advance the work at the UN level as well, and but also it will have an opportunity to for the court to lay out how this harmonization works in practice. And one aspect that Mexico dealt with in the context of the oral hearings was also the what are the benchmarks as to measure due diligence. And one aspect, and it was also already made in one question, was about loss and damage. And Mexico raised the argument that for developed countries to fund and address loss and damage was a way to assess due diligence, and also it's in line with the CBDR principle, which for Mexico, CBDR, which was also tried to be eroded by the comments by some delegations, but at least for Mexico, it's a well-established principle with a cross-cutting nature that informs the entire regime for climate change. So this is a great opportunity for the court, and well, we cannot anticipate at this moment what the court will do, but the very fact that the court also was open to hear experts from the IPCC on the reports. That also creates the expectation that the court will be informed by the best available science in its answer to the General Assembly. Thank you very much.
Thank you very much, Alfonso, for joining us. Kate, some final comments or also reactions to what other panelists have brought up?
Well, I think it's very difficult to pull out something as the most significant from this really groundbreaking proceedings, but maybe I can answer that on a sort of very specific and very broad levels, missing out all of the middle. So very specifically, as I've said, I think, for us, it would be really valuable to see conflict emissions from occupation contemplated as being regulated by the rules of international law that apply to armed conflict and occupation, but zooming way out and leapfrogging all of the other legal pronouncements that we're looking forward to. I think really the way the ICJ was used, and this is coming back very much to what Louise was emphasizing, but what everyone has emphasized, and which all of us who were there felt very deeply, to see the ICJ being used, the voices that were being showcased also inside the proceedings, the broad participation of people who've never spoken before the ICJ, including me, by the way, but many of us there for the first time. I mean, the number of women who were speaking as just one thing, let alone the number of people from nations who'd never been represented, indigenous lawyers and activists and thinkers who were able to present their analyses and views. I feel that in itself is shifting what we understand as the purpose and the function and the relevance of these international legal fora in a way that can only be celebrated.
Thank you so much, Kate. Luis?
Thank you. And yeah, I really want to echo Kate's words there. And I think maybe the most significant is actually yet to come. We've had so much momentum leading up to the hearings, celebrating this. For a lot of us, it's the first time actually seeing each other since the hearings in December. What can we actually do to maintain this momentum? This dream that started by Pacific law students that landed in historical hearings last year. What can we do? I think in all our respective fields of expertise and areas of power, all of us in this webinar and the people back home, we really have to continue to make sure to put pressure and to transform what will be, a hopefully progressive advisory opinion into actual change on the ground. And this is the best way we can do this in our various areas of expertise. For instance, for me specifically working on climate litigation with impacted people, we will be using the advisory opinion in climate cases against governments, against polluting corporations. But I'm sure that all of us come from various fields, whether it's negotiations or academia or working on the ground with impacted people. Let's just continue to make sure to really transform these legal decisions into change. Thank you.
Thank you, Luis. Zachary?
Yes, there's not much more I can say. The main point that I wanted to make was that I firmly believe that this advisory opinion, no matter what the result, is only the beginning. And echoing the comments that my colleagues have made, it's really for us to go forward and use this in a way that we find it beneficial. And again, for a lot of persons, there was doubts, there was serious disbelief that we would even make it this far to appear before the ICJ, to have the ICJ with a unanimous request from the UN General Assembly to hear an advisory opinion about the obligations of climate change. But we did it. It happened. We are here. And now I hope for everyone who is listening and everyone who is a part of this webinar as well, that we are clear that when it is that something is so pivotally important, so vitally crucial to society itself, we cannot just wait for someone else to do it. So the next group of people who come up with the next stage in this step, it need not be, island students from the Pacific. Let's also think about what we can do as well to support the young people, just like how they supported us with this process.
Thank you, Zachary. And thank you to all our panelists for the wealth of knowledge and clarity they've offered today. It's really amazing hearing from all of your perspectives, especially being involved directly with this historic climate case. These ICJ proceedings will mark a before and after in how states respond to the climate emergency. So I stress and urge every one of you tuning into this webinar to keep in mind that climate change is about you, international law is about you, and this advisory opinion is about you. So as the court deliberates, it's on us to keep the momentum going in our respective spheres and plan ahead into how best to work with governments, civil society, and communities most affected to ensure this decision can have meaningful impact. On behalf of CLWICJ and Pacific Island students fighting climate change, we thank you for being here today with us and invite you on our next webinar tomorrow. Thank you so much. Have a great rest of your week.